My name's Lucan. These are my musings on insolvency and business prosperity. And this is the right to work. Yesterday I was preparing a case summary for a article I've just written for the Worrells on the Pulse newsletter, and I thought today it might be fun to talk about that on the right to work. In 1994, Mr. Williams bought a property in joint tenants with his wife, and then in 2006, the mortgagee, the NAB, obtained an order for security subject to its mortgage. Fast forward a few more years, and then in 2009, Mr. Williams became bankrupt, and my former business partner at Worrells, Malanos, was appointed as the trustee in bankruptcy. Now, Mr. Williams remains bankrupt even to this day, some 12 years later, and that's because he's never lodged his statement of affairs. So his 3-year term of bankruptcy won't commence until such time as he lodges that document, and therefore he remains bankrupt in perpetuity at this stage. Mr. Malanos determined that the value of the property was insufficient to discharge the mortgage, and so in 2011 he elected to disclaim the property, subject to his authority as trustee under Section 133 of the Bankruptcy Act. Mr. Malanos retired from practice in 2020, and sadly, my good friend and colleague passed away in November 2020. Events conspired that I was appointed trustee of the bankrupt estate in April 2021, following a notice from the NAB in January 2021 that its 2006 order for possession had expired and that it had elected to discharge its mortgage. So, as a newly appointed trustee, I determined that I had an obligation under Section 19 of the Bankruptcy Act to try and recover the estate's interest in this property if there was one, and so I made an application to the court for an order pursuant to Section 133 subsection 9 of the Bankruptcy Act, revesting the previously disclaimed property in me. So the big legal conundrum with this application was whether I could claim an interest in the property in circumstances where that interest had been disclaimed by the previous trustee. I'm going to do no justice to the full judgment in this short video. So what I'll do is I'll leave the case name in the description, and those interested can look it up. But in summary, His Honour found that the jurisdiction conferred by Section 133 subsection 9 of the Bankruptcy Act is determined by the making of the claim and not the vindication of the claim. And so, having determined that the conditions were satisfied to enliven the court's jurisdiction, His Honour determined that it was just and equitable for the bankrupt estate's former half interest in the property to be vested in me, in my capacity as the trustee of the bankrupt estate, for the benefit of the creditors of that estate. Better just concentrate on this for a second. Oh, that's wet. Oh, definitely right on wet planks, eh? And so, the new legal precedent established in my case is that a trustee in bankruptcy can claim an interest in previously disclaimed property. So there you go. An interesting tidbit for the lawyers and insolvency practitioners out there. I hope you enjoyed it. And as always, thanks for joining me today on the ride to work. Wheelies are fun.